Hi, this is chapter 10, reviewing and investigation skills. Now we're getting into some of the fun stuff. If you watch TV shows like Lincoln Lawyer, he's got his paralegal doing all this stuff, suits. Lots of fun stuff you can do at this point. So, what we're going to cover today. Explaining the importance of the initial contact with clients and witnesses. Describe the issues that prepare for an interview. Describe the issues of conducting an interview. Explain the difference between moral and ethical consideration. List the forms of privileged communication. Explain how expert witnesses are used in litigation. Explain the steps and process of conducting an investigation. Describe the role of the Freedom of Information Act in investigation. And describe methods of locating witnesses and the function of the trial. So, first interview is called the screening interview. It's the first meeting, and it often takes place with the paralegal. You don't want to get too much information before the actual client has been accepted. So you're just trying to get some basic information, not the details of the incident or confession or anything like that. You're just getting some background material. Name, address, where did this happen? Is there a police report? Or are there doctor records? You're not even asking for the records, you're just asking if they're on. And paralegals can determine basic information just as potential parties an initial date of entry to check for conflicts and statute of limitations concerns. You don't want any, you haven't accepted this person as a client, so you don't want client confidentiality. That's for the attorney to do. So you don't want them to tell you anything that should be confidential. Potential clients should be advised that information shared might not be subject to the attorney-client privilege. Now, you want to give them plenty of information to make sure they understand there is no confidentiality at this point. Implied attorney-client relationship can exist if the client believes they are represented. So you have to be very clear. Firm, before that happens, before they accept it as a client, they need to check conflicts of interest with the paralegal and attorneys prior to accepting representation. Okay, your attorney represents Bill Jones Towing Company. We handle all matters with the towing company. Mrs. Jones comes in and says that she wants you to be the lawyer for the divorce among Bill Jones. So that's a conflict of interest. You're representing the business and you're representing the way. It is important to learn the date or time frame of when the event happened to ensure that the client is within the statute of limitations. Certain things have to be followed within a year of the incident. Once the attorney or firm has had a chance to review the information gathered during the interview, either a letter of engagement saying we accept you as a client, looking forward to working with you, or non-engagement should be said. Sorry, we looked things over, there's a conflict of interest, we can't be representing you. And even saying there's a conflict of interest might be, revealing confidentiality, so you just say you can't. Preparing for the interview. So, checklists are helpful in making sure information is gathered and should reflect the potential cost of action. Basic, what kind of thing are we dealing with? What area of law are we dealing with? What's the questions will be? Make sure the physical surroundings reflects the type of interview. Do you want to be a comfortable interview? This is a personal matter, or do you want to more formal because it is business, dealing with business people. And the initial interview will set the impression for the client. So dress and appearance should reflect this. Be aware of multicultural sensitivities of the potential client. You know, they might have issues dealing with their dependent divorce, and their religion can, you know, be much more strict about divorce. So you have to be understanding of them. You know, we live in a multicultural society, so you have to be aware of that. You don't go in with your views, you're just going in with no views of your own. Letting them. Always make sure that you are a paralegal. Make sure that everybody knows you're a paralegal and not an attorney. Listening skills is essential. Focus on what is said and how it is said. It's not about you, it's about them. So you want to know what they said, sort of like what they said, knowing when they said it, how much was it emphasized on this, you know, because that might be worth for you to follow up and stuff. Leading questions suggest a desired response and are not very good at eliciting information during the interview. So you say your husband beat you on December 16th at 5 p.m. Is that correct? It's a leading question. More would be to describe a relationship with your husband around this time. Those are called open-ended questions, and they give the opportunity for the person to tell the story of events and are good at learning additional information. You might find things are very different when you hear them tell the whole story, and you might want them to tell the tones because sometimes they leave out details. You know, they'll get more details, things that you can follow that give a different perspective to the piece. Moral obligations are based on one's own conscience or the person's personal rules of correctness. You know, that could come from your religion, your background, your family. That's all morality. Then there'll be ethical obligations. Those are responsible for the profession under the ADA level rules. Now, those might sometimes conflict because you might not like your family, or they might be doing things that are immoral, but they're not doing. And all of that includes service and representing a client. Ethical obligations apply to all members of the legal team, including acting on behalf of the supervising attorney. So, you may think such and such is horrible, racist, misogynistic, jerk. But you have to leave that behind if the attorney has taken on this person as a client. You don't, but public being personally attacked, you know, you don't be attacked, but you just sort of have to, like, you can't judge them or be affected how you perform your job based on the kind of person. You have your job and your obligations to be. Now, some types of communications are privileged, meaning you can't force someone to talk about this. These include communications between an attorney and a client, the doctor and patient, the often medical records are, you know, included in that, but the communications, you know, with the patient are priest penitent communications, you know, things that have been confessional or privilege, that you can't force the priest to say it was penitent, then wait. Spousal communications during marriage. So you can't force spouse just by this. But in some cases, you can let them waive the privilege. And if they would like to talk about things during the minutes, they can just force them or the state. Very indefinite interview. An expert is an individual with a background, education, or experience that qualifies him or her to give opinions on certain subjects. Experts may be called in trial to give opinions or retained by the firm to provide advice during trial preparation. Information used to develop the expert opinion for the testifying expert is discoverable by the other side. So let's say you have Someone who's renting an apartment and their children are sick. And do analysis of the apartment and find out there's something like lead paint. Well, an expert would come in and explain the effect of the lead paint exposure to children. Is this not something people would know offhand? And not the average layperson. There's certain people in the medical field who specialize in this. So you'd want them to explain how that exposure to this illness. Investigating claim. Prior to the filing of a lawsuit, the legal team must gather relevant information regarding the cause of action and determine if litigation is warranted. Determine the elements of factors that need to be proven around anyway. Finding the affirmative defense or think of responses by the defense to the allegations. And obtain any official reports of documentation that exists as a police report or medical record. Do you, is this case worth taking on and spending your time and energy? They come in and they say, hey, I've sustained this injury from this car accident. You get the police report, and the police report says it, doesn't like blame on the other person, and the doctor doesn't say anything about this injury, causing discomfort. So, right. A lot of times people like to sue each other just because they don't like each other. And, then you have to really figure out whether it's worth your time and whether they can pay you. But sometimes it's like the reason you don't want to take the case is the amount of money that can be collected isn't worth your fee. During all the investigation, do a fact analysis, which brings together the interview along with any documentation determining if the cause of action can be proved. If relevant, try to visit the physical location and where a number of people describe the location and get a sense of the location where the event occurred. Going back to our parking lot example, go out and look at that parking lot, see if it's safe, see if it's well lit. Get your own insight in it. Gather any tangible evidence that relates to the case. Make note of any evidence that is stored and reported to report from the opposing counsel. Right? So it's not part of discovery. You can get in trouble for impeding discovery by not providing the evidence because the evidence is already destroyed before doing this. Conduct a timeline to put the events in order. If there are any documents or information needed from the government, submit a Freedom of Information Act request early because they can take some time to process. Getting any sort of things from the government is slow. Locate potential witnesses. Use just directories including the internet or Facebook or any way that you can find these people that are disappearing. Because someone forgot to get their phone number. You can really find a lot of people on Facebook. If you can, just their name, then you can find all sorts of information. You can also do that like people search thing, search engine. And look at the case from the opposite perspective to ensure that nothing is going missed. You're going to play yourself, you're going to go on the other side. How would you defend if this person is being sued? And what were your possible defenses are so that you have things over that will negate their effect? Freedom of Information Act, FOIA, is a federal statute designed to make available to public information possessed by the federal government and its agencies. There are some limited exceptions, but many agencies make their information available online, so you can search through there. Sometimes you can find out people have police records. You take these line based on their wording, find out if they've been arrested for fraud. Yeah, even when they make terrible. Locating witnesses. Okay, that just like we just went into, including trade organizations, you see the some members that are available. And as I said, general web searching, people search. Background check.com, things like that. Trial preparation begins with the first client contact. From that moment on, you should be taking notes, documenting everything. Trial notebooks is the name given to information about the case that is maintained in an actual notebook with tabs for each major activity, party, expert, or element of the meter. It's like a little binder. Everything about the case together. These must be maintained constantly to ensure that all of the necessary information is included and updated throughout the proceedings. And you don't decide what needs to be in there. You put everything in there, and the attorney decides what for you. Okay, that's it for this chapter. And good luck and have a great day.